again everyone, and welcome to the fourth and final video in week 2 of our admin law course. This video finishes off our discussion of the ancient prerogative writs of certiorari, mandamus, prohibition, habeas corpus and quo warranto by tying off a few loose ends so that we'll be ready to start looking at administrative law in the more modern world. The first thing I want to do in this video is to observe that the writs we've all been talking about are common law writs, so they came out of the system of common law. But as all of you should already know, over the centuries there was a parallel body of law developing in England, the law of equity. Now I'm not going to go through what equity law is and how it developed, or this would turn into an equity video instead of an admin law one. If you don't remember, now's a good time to pause this video, go brush up very quickly, and then come back. One of the features of equity was that it developed a range of more flexible remedies than the common law. If a plaintiff sued in the common law for, say, breach of contract, usually the only remedy available to them would be damages. Equity developed a range of other remedies. Two of them, injunction and declaration, are important to us here. Remember though that all the other principles of equity still count. Particularly, equity follows the law. So typically, an equitable remedy like declaration or injunction won't be granted if there's a statutory or common law remedy which will do the trick. Let's have a look at those equitable remedies relevant to admin law, starting with injunction. Injunction is an order by the court to either do something or refrain from doing something. So there's two types of injunction: a mandatory injunction, which is kind of like mandamus in that it makes someone do something, and a prohibitive injunction, which is kind of like prohibition in that it stops someone from doing something. Let's look at some examples. In Coward and Allen, a series of search warrants were executed on premises relevant to Mr. Coward, following allegations about money laundering activities and unlawful financial transactions. Mr. Coward held the view that the warrants were invalid. He challenged the validity of the search warrants and asked for an injunction against the execution of those warrants and an injunction against any reliance by police on things found under the warrants. Now, the High Court ultimately found that the warrants were valid, but there was no doubt that if the court had agreed with Mr. Coward, the execution of the warrants would have been prevented by an injunction. There's a key difference to understand, though, between a writ of mandamus and a mandatory injunction. Remember in the video on mandamus, I said that in order to obtain mandamus, you had to show that the person being commanded by the writ had an actual duty. No duty, no mandamus. Well, that restriction doesn't exist for a mandatory injunction, nor for that matter does it exist for a prohibitive injunction. The court can issue any injunctions it needs to in order to do equity. There's a flip side to this though. By its very nature, an injunction confines a person's freedom. Prior to the injunction, they could do something or not do it. Once the injunction is in place, they no longer have any choice. For this reason, the courts always need convincing that an injunction is truly justified. Again, this is somewhat different to mandamus, where the person was already under a duty anyway. Mandamus doesn't remove someone's freedom. It just gets them to do what they were already supposed to do. Declaration is a little bit different. Under the remedy of declaration, the court authoritatively declares the rights and responsibilities of the parties. So, for instance, a court might declare that a certain decision was made improperly. This looks a lot like actions taken by the courts under the early writs of certiorari, when a decision was brought before a higher court for inspection. It's important to understand that declaration doesn't actually change anything or compel anyone to do anything. It does, however, provide a mechanism for public accountability. It provides the court with a way to examine a decision and say whether a particular department is using its powers properly or not. That on its own is helpful. A good example came in the Church of Scientology against Woodward, a High Court case. Now, the Church of Scientology, I think it's fair to say, is a controversial organisation. It's been accused of being a cult, among other things. Personally, I don't pretend to know anything much about Scientology. However, the Scientologists believed that because they were controversial, ASIO and other government agencies were conducting unlawful surveillance and spying on them, and they wanted it to stop. And so they applied to the High Court for a series of declarations which, if made, would have made it clear that in the opinion of the High Court, those activities should stop. Now, the Scientologists ultimately lost their application for some fairly technical reasons, but the court made it very clear that it did have the power to make those declarations. And even if they lost, the Scientologists were still able to bring the government before a court and express their concerns. The real advantage of these causes of action, and in particular declaration, is how flexible they are. There are a lot of detailed rules about certiorari, mandamus, prohibition, even habeas corpus. There are perhaps even more rules when it comes to injunctions. However, the court can make pretty much any declaration that seems appropriate to it. The declaration, on its own, doesn't change anything. But a government, faced with a declaration by the court that it's done the wrong thing, will inevitably take steps to fix the problem. It's just impossible to imagine the executive government taking the position that even though the court says they've done the wrong thing, they're just going to keep on doing it. Now, almost all the causes of action that we've talked about so far were specifically written into the Australian Constitution when it took effect in 1901. Section 75 of the Constitution says that in all matters in which a writ of mandamus or prohibition or an injunction is sought against an officer of the Commonwealth, the High Court shall have original jurisdiction. This means that not even the Parliament can remove the capacity of the High Court to hear a case where one of those three causes of action are in place. Elsewhere in the same section, the High Court has original jurisdiction in any case in which the Commonwealth or a person suing or being sued on behalf of the Commonwealth is a party. This effectively gives the court the power of declaration, among other things. These constitutional provisions are then supported by, in particular, sections 30 and 33 of the Judiciary Act 1903, and finally by Part 25 of the High Court Rules 2004, which sets out the procedures for applying for those writs. So you can see Section 75 of the Constitution brought the old common law English writs and gave them constitutional authority in Australia. As a result, strictly speaking, they're known in Australia as constitutional writs. They still exist and they can still be sued. As we're going to see in future modules, though, they're very rarely sued nowadays because our system of administrative law has advanced and there are now better ways to achieve the same things. Okay, so here we are at the end of week 2. This week we've looked back into history to find out over the centuries how central governments have controlled local decision makers and how that process gradually morphed into a process whereby individual citizens could challenge government decisions. We've learned about certiorari, whereby a court can call a decision before it and review that decision. We've learned about mandamus and prohibition, which are two sides of the same coin. A writ of mandamus says to a public servant, "You must go and do your duty," while a writ of prohibition says, "Stop what you're doing." We've learned about the writ of habeas corpus, under which a person who is in detention can demand to be brought before the court so that they can challenge their detention. We've learned about the equitable remedies of injunction, which covers much the same ground as mandamus and prohibition, and the equitable remedy of declaration, by which the court can tell a government agency that its decisions are unlawful for some reason. And we've seen how these powers were ultimately written into the Australian Constitution. Over the centuries, you can see the slow development of administrative law. But the development was slow, and it was even slower in England, perhaps because the class system of England made people less likely to challenge their rulers than the relatively egalitarian Australians. Along the way, though, the courts developed rules for decision makers to follow. You see, when they issued, say, a writ of prohibition, the courts would indicate what was wrong with the decision. And as a result, decision makers knew to avoid that error in the future. The more this happened, the more the common law evolved a set of principles for proper decision making. From next week, we're going to look at the contemporary expression of those principles as we start looking in detail at administrative law as it now operates in Australia.